section under which all these three people were arrested, that section had been declared void. And at law, if something is void, they also have the expression, it appears in the writings that I saw from Alex, it's void ab initio, it never existed, it was never there, right from day one. Meaning then that there is a very strong argument to be made in favor of the view that that law is non-existent. What has happened now is that those arguments, I think, were put before the magistrates, and that to appear that all the three magistrates rejected that argument. So the next thing is to take up that rejection of that view, and it must be done quickly, so that this view is really taken up to the High Court and then to a higher court, because it's a very, very important matter, given that what the Constitutional Court has been saying in respect of that, it was following precedent from other countries. If something is void, it is void. It is not there. It is nothing. So it could not have been resurrected. So I would call that view the dominant view. And for now, that should be the view that we ought to be following. We would only explore other views. There are so many other views that are in academic circles, so we shouldn't use them here. I mean, you know that in academia, you would never get one view. You will get people expressing other views and so on. There is, if some listeners want, they should go and read. You will get an American view. It's a minority view in the United States, which would say that even when a court declares a statute void, it does not repeal it. But I don't want to make loud this view, because I think it will be taken by some of those that want to be very oppressive and say, well, it was declared void, but never repealed. So then if it was never repealed, it was resurrected. But that's a very nonsensical sort of reasoning. So what I would say is, I think we should take the view, which I am calling the dominant view, is that this offense in particular is currently non-existent. But because